to all of you a little while ago, so you know how much and how I feel about you. And so I want to thank God for you. Sister Sati, let me make you a deal. If you come on Saturday, we'll change the name of the day from Saturday to Saturday. How about that? Is that an incentive for you to come, Sister Sati? So from now it will be known. If you come, we'll call it Saturday instead of Saturday. All right. Okay. Yeah. Let me get serious. Somebody said, "Oh, she like that." Yeah, you all promise to always laugh at my jokes, huh? Anyway, let's get into what we came here for tonight. As you know, last evening, thank you, Sister Cindy. Last evening we had Attorney at Law Marilyn Destiny Joseph with us, and she shared with us about estate planning. And I know many of you had questions, and you didn't get them answered. Some people got their questions answered, but not everyone. She is back. She has consented to be back with us this evening to answer the questions that we have. I understand we do have questions. So firstly, I don't know if Joshua will be calling out the question, but first of all, let's welcome her back. Marilyn, welcome back. And thank you so much for consenting to be back. I hope she can unmute, folks. Let's make sure she can unmute. There she is.
Hi. Good night, everybody.
Wonderful. So I want to start off. I know we have people with questions, but I want to start off with a question. And my question is this: how do I know that I have not? How do people know they have been named in a will? Because I don't know if somebody left me a house somewhere, or a car, or land, or some kind of thing. Maybe somebody did that in their will and I don't know. So how does someone know that they have been named in a will? Whose responsibility it is to let the people know? That's my question as we start.
That's the role of the executor or the executress of the will. They would call a meeting for the reading of the will after the person dies. Okay? Usually they will call all the beneficiaries together. Only people who are to benefit under the will would be part of that meeting. All right? So if you weren't called, most likely it's because you are not named in the will.
Anything.
All right? Yes.
All right. And the thing is too, just a follow-up. I know the executor or executress, they're not supposed to be biased, but suppose they didn't call me. Suppose it's somebody that doesn't like me. And can the will still be read without me being there?
Yes, will, anybody could come together to a will. But if it is that you, like your father died or somebody died, and you feel that something was mentioned about you in the will, and they didn't call you or whatever, when they're probating that will, it is lodged at the probate registry. Everything is filed there. So you can do a search at the probate registry and get copies of the will and what was filed. And from that, because you are a son, because you have to have some connection with the deceased, right? Because you are a son, and so you would be entitled to do a search and get copies of what was filed. What was filed, if there's a will that was filed, you can get a copy of that. And from that, you can know if you were mentioned in the will. All right. If you were mentioned in the will and nobody called you or so, then you can take the executor to court.
Okay,
all right.
All right. I'm looking for an executor. That's one last thing before I hand over to the other question. You mentioned a word there. It came up last night, and I was to ask you because sometimes we assume that people understand everything, especially when you're accustomed using the jargon. And you keep talking about probate.
Okay.
What exactly is that?
All right. Okay. All right. So when somebody dies, whether and they leave a will or whether not, all right, in order to handle their estate, all right, an application would have to be made to the court. Now, the probate division of the court is the division that deals with assets of individuals who have died. All right. So if there's nobody to inherit what was left and so, it goes to the government. All right. If it is,
Really?
yes, if there's nobody to inherit, all right, it goes to the
Oh,
government. Yes, it does. All right. So if there's somebody, so the probate, now there's the grant of letters of administration that is applied for. That is a document you get from the High Court after an application has been made by the personal representative of the person's estate. That could be a wife. That's when somebody didn't make a will. Could be a wife, his children, any next of kin can make that application, but in order. So if the order is with the wife first. If there's no wife, then any one of the children. If there are no children, then his parents or her parents. If there are no parents, then it goes to siblings, and then it goes down the line to nieces and nephews and all of those things. And so when you're applying to the probate department, of the judiciary, you're applying for letters of administration. All right. If there's a will, you apply for a grant of probate. And that document gives you the right to handle the person's assets. All right. So
okay.
that basically it is.
Thank you. Got shaken a little bit with
But
that thing
before
of
you go in,
going to the government.
I have to correct something.
Go ahead.
All right. Somebody asked me about a living will last night. And somehow I gave them the definition of another type of will, and I want to apologize for that, right? Now, I talk about the simple will that you can make with two witnesses, and then all of those things are important when you're doing a will. The two witnesses, they have to be how they have to sign in front of each other, and the testator and all of that. All right. So those are the things that must be in place for all wills. And so there's a simple will where you leave all your assets to whoever and whatever. All right. And then there's there's different types of wills. So then there's a joint or mutual will that you can make. And this is usually with spouses. So let's say you and your wife decide, well, we have children. So we build a house, whatever it is, it goes to the children. You can make a joint will, with both of you signing. That will, once either party dies, cannot be changed. All right? So the protection is, should the other party get married after, that property that was there between the husband and wife cannot go to the spouse, the new spouse. All right, understood? So with that joint or mutual will, it cannot be changed once one party dies. All right, that is the mutual will. All right, there's also the mirror will, where the two party, it could be husband and wife, brother, sister, whatever, they have, the will is exactly the same. It's just that I leaving everything to you, and your will saying it leaving everything to me. All right, or we leaving everything to the children. All right, and so the will is stating the exact thing. That will can be changed, right? That's the mirror will. And then there is the testimonial trust will. And somebody asks about their grandchild leaving things to their grandchild. So you leave in your will, you appoint a guardian you're setting up a trust. Sorry, you're setting up a trust in your will so that the money can be distributed over a period of time. So it's a testimonial trust will. So that comes into place when you die, not before. All right. So it allows for the management of the assets and distribution upon your death, but it is shared out to the beneficiaries over a period of time. I think somebody asked about that, right? And I want to mention this also, the will made in contemplation of marriage. Now, if you make a will now and tomorrow you get married, that will is no longer valid. right? Let that sink in. Marriage revokes all wills. All right? So daddy make a will 20 years ago and leaving it whatever, and daddy come and get married now, that will is revoked by marriage. Unless you make a will in contemplation of marriage. So what has to be stated in the will, whoever you're leaving whatever for, all right? And you're saying, well, you're making this will in contemplation of getting married at a certain time. You have to give the name of the person that you're getting married to and the date or the time frame within which you expect to get married. All right. So that's only how a will done before you get married can survive the marriage. Okay. So that is important that people know. And then there is the last one is the pour over will. And this is made in conjunction. You set up a trust even before you die. And you put all your assets in the trust. But maybe there's a grandparent that left something for you that you didn't even know. All right. So what you do, you make a will in conjunction with that trust so that whatever is left over when you die, it forms part of the trust. All right. So that is simple. I hope that clears up a lot. Maybe
Okay.
open it up to more questions, but
I tell you, but something sounds kind of strange because you said the first time that if you make a will,
Mhm.
and one of the persons die, then the will
one of
remains the same. All right,
one of the person die. Who are you talking about? Who?
husband and wife. The wife dies, so you said the will remains the same. The second
That
wife.
is in the mutual will. It's a
Mm-hmm,
difference in the will, right? The mutual
mm-hmm,
will is one will that both of you are making,
right.
and both of you are signing that will.
Mm-hmm,
All right? That is like a contract and agreement that you're making that we're leaving all the assets to the children or whoever you all decide that you want to leave it for. If
mm-hmm,
one party dies, all right, the other party that is alive cannot change will or do anything else but what is on the will in the agreement. All right? That is the mutual will. All right?
mm,
Understood. So that one is more rigid that you cannot change that. Whereas the mirror will, where both of you have the same information, both of us leaving it to the children. If I die, everything goes to the children. If you die, everything goes to the children, that kind of thing. That can be changed. All right?
mm.
Mm.
Oh, I see. So if I decide we make this will together and it's going to the children and
Mm.
my wife dies, you say that can't be changed. So if my
If,
wife
if
died,
it's a mutual will,
if
that
it's a
one.
mutual will, right?
Mhm, mhm.
But then after she died, I found out that one of my sons is a scamp. He's
Can't
good
change
for
it.
nothing. I
You
can't
can't change
change
it.
it.
You can't
Oh
change
my
it.
goodness, because I
Mhm.
can't wake up from the dead, so all right.
Yeah.
I
But it's
hear
a
you. I hear you.
safety too, in that if
Mm-hmm.
you should get married again, and
Mm-hmm.
your whatever is between your first wife and you goes to the children. If you have
Children.
any other assets after that, you can give to the new wife and new children. But it's a safety because you don't want when you die, the children get put out, the wife get married again, and the husband don't want your children there and all kind of things.
Mm-hmm.
So you can put that
Understood.
in place so
Okay.
that a safety for your children. All right?
Understood. Understood. Okay, guys. So I know we had some questions. I don't know, Joshua, if you have the questions, you'll be asking. I also want to ask
If I could
if you
answer.
do have a question, you'll be able to answer them. If you do have a question right now, just put up your hand. We'll acknowledge you, and you can ask your question. All right. So, go ahead,
Before we go
Joshua.
to we have two questions that were asked
Hi,
last night
Joshua.
that we want to ask first, right? And then
Mhm.
we'll go on to the people who have the questions for tonight.
Mm-hmm. We
Okay,
see Beans. So after your two questions, we go to Beans. Go ahead.
okay. So the first question is, can a deceased husband make a will and leave his wife nothing?
Well, if you're deceased, you
If
can't
he
make a
deceased,
will.
he can't make
Well,
a will.
well, meaning, yeah, meaning, meaning that he made the will before, right?
Uh-huh.
And he, in the will, he doesn't leave his wife anything, and then he dies.
He
Is that a
can
thing that he can do?
he can do that, but the will can be challenged by the wife. It could mean that he didn't have her in contemplation when he was making the will, or something came over him. And also, when two people are married, especially if it's a long marriage, that even though one party may be the breadwinner and build the house and do all of that, the court sees the indirect contribution of the wife or the other party towards the accumulation of the assets. So the wife would still have a share. It starts at 50-50. All right. So to totally disregard her in your will, it can be challenged. Okay. And so if it is a new wife, and or you have already given her, you've given the wife things, and so you can place in your will, I leave $1 to my wife. I've already transferred property into her name, or whatever it is. So the court will, or if it is challenged, the court can see that you had her in your contemplation. I left $1 towards her. Or if you know, some people have seen wills where people say, I leave $1 to my wife, she never treated me well, whatever, and they put a whole long thing. All right. So if it is challenged, the court could know that you had your wife in contemplation when you were making the will. All right, so it is better if you mention the wife in the will that I live in. So, but you have to be careful that even though you have accumulated, you are the one that have financed most of the assets of the in the marriage. The indirect contribution, because she's cooking, cleaning, making children, giving you sex, doing all of those things, because she's been doing all of that. If you had to pay for all of those things, you could not have afforded the house. So the court looks at her indirect contribution towards the assets. All right, so you can't just leave her out like that. Especially if it's a long marriage, if it's assets that you had before the marriage, all right, that she came in and met you with all of those things, all right, well, then you can just put, I leave $1 for her, everything for my children, and so. But as I said, if it's a long marriage, you have to think about her interests in whatever assets.
Oh, wait, let me just ask you something quickly before you go on, Joshua. So if you do that and you're leaving $1 for your wife, the executor still calling her to come to sit down to hear the
Yes,
will,
she has
to
to
hear she got
know.
$1?
Yes, she has to know that her husband left her $1.
Wow. Wow. Okay.
And,
Okay.
yeah, there may be some reasoning behind it and things she would know and whatever, All right?
All right. Joshua?
The second question that we have is there's a husband, right? And let's say he acquires a property, right? During a marriage, right? And the wife contributed nothing towards that property at all, right? And he doesn't really make a will, but he just comes he acquired the property of his own volition and he pays for it, he does everything. She doesn't contribute anything towards it. But after they get divorced, is she entitled to half that property? Is the question.
Okay. The thing about it with property, you're going into a different realm now. With property and marriage or so. All right, as I said, the court looks at the indirect contribution of the wife, especially if it's a long marriage. If it's a short marriage and let me say you all were together for 5 years and then you split up and he continued paying, but you or whatever, but you're still married and so and the court will look at the period under which you were together and award her a certain amount from that. All right. If it is that especially if, as I said, it's a long marriage, 15 years and more, the wife is entitled to half of whatever. If it is that once he got the assets during the time of the marriage, all right, it becomes marital property, all right, marital assets. So according to how much, let's say it's a mortgage, how much that was paid up to the time before the separation, or before the separation, that she would be entitled to. I don't know if I'm making it clear. Understood?
Yes, we understand. Yes,
Mhm.
yes. Okay, so we have two hands up now. You'll take Brother Beans first.
Good night.
Hi, Beans.
Marilyn.
Good
Hi.
night.
You started off making a correction
Mhm.
about the question asked last night, because the person had asked what is a living will.
Okay, did I go into the living will? Okay, the
No, you
living
did
will.
not. So just ask me.
All right, let me just ask. The living will is a will that is made for medical treatment in the case where you don't have the capacity to make a decision. So maybe that you're losing your mind or whatever it is, and you want to make you want certain medical treatment and so on, to ensure that you can make that directive in the will. Now that will is only for medical. It is not for them to end your life before, or anything extreme. All right, it is just for medical treatment. But you still have to do a will for your assets. That does not cover assets. All right, the living will does not cover assets. It's only for medical reasons, right? In some case where you're incapacitated, you may become that. You do a will and give direction for your medical treatment. All right?
So it's similar to having a life insurance with benefits that you can get while you're alive still, before you have an accident as such.
I didn't get that. I didn't get what you said.
Like a life insurance would be to do with if you die, right? That somebody benefit if you die, a life insurance. But there's some life insurance now have benefits that you even can get while you are still alive. So a living will is like you want
No,
to
well, a
make
will
sure,
and insurance is two different things, you know.
right? I understand that, but I'm saying that
Uh,
in the living will, so a living will, you will make up a normal will and a living will, two separate documents. And the living
yeah.
will is just to take care of you medically.
The medical treatment that you would give directive for in the case that you cannot, you don't have the capacity to make any decision or so, you can give directive in that will.
Can that also say, regardless of what you don't subscribe to euthanasia or something like that?
Yes. No, but in Trinidad, you cannot direct that your life be ended or anything like that. You cannot. There may be countries that you may be able to do that, but not in Trinidad.
Okay, thank you.
Yeah, well, that was my next question actually. If you can direct that. And again, we using a big word there that some people may not know, euthanasia. And
Yeah.
that's the taking of your life, right?
Yes. So that's
You
why
could
I
tell,
said the ending
mhm,
somebody's life. Yeah.
yeah, sure. So I can't tell them pull the plug on me if I get paralyzed, or I can't do that in Trinidad.
No.
Wow.
Mhm.
So that'd be murder.
Yes.
They can get charged.
Yes.
What a thing. Well, then, I
Give,
mean, a
give
will
me
is
a
a will.
little, if you say, give me a little injection, if I get crippled or so, and I can't walk again, or I lose my sight, you cannot put that in the will. It's for medical treatment in case that you of yourself cannot give directives for your medical care. All right, that is the
Question:
living will. Mhm.
if I have something, I can take me to Canada. I say, if things get really bad, take me to Canada and take care of me there in terms of euthanasia.
What's that?
If I give directive in the living will that I hear it can be done in Canada, and I said if in the case I reach a point where it's overbearing and they don't want to carry on anymore, take me out of Canada and deal with me there.
Well, you cannot put that you want to end your life and take you to Canada to end your life. You can put in the will that you would like to be get medical treatment in Canada. You understand? And they're over there now. If you cannot put that in your will that you want your life to end or them to end your life, or you cannot put that in the will because that would not be valid. All right, in Trinidad,
No,
for them to take you. You can
what,
put,
what,
well,
what,
take me
what,
to
what
Canada and give direction. Otherwise, I say, well, if you take me to Canada, do this, whatever. But that doesn't, it cannot be said in the will.
Okay,
You
hold
understand?
on.
Mm-hmm.
Last night you said a will could be written on a piece of paper and so on, and what is witness? So if you get witnesses who witness that to say, let's say make 2 life wills. One says medical treatment, the next one says take the kind and take care of me if the end seems inevitable, and that is witness, and you take them, the person is taken to Canada. The first life will say take me to Canada for medical treatment, the next one say take me to Canada and take care of me.
Nobody, whatever will is saying to end your life, it is not valid in Trinidad and Tobago.
But then, if you take it out of Canada, would it be valid there?
I don't know. I don't know the laws of Canada.
No, I just using the word Canada. I mean, to some place then. And the point I'm trying to make is, well, I understand it's not valid here, but if a will is something to be kept in
No, but you don't
secret,
even need a will to do that. If it is that you decide, well, I want to take my life and whatever, you can take a plane and go wherever and end your life, or you can take your life right here.
No.
The thing about it is if you want to do a will for somebody else to take your life, all right? If you want to do a will for that, that is not allowed under our laws. All right. However, you want to maneuver this, that would be up to you, but it is not under our laws. All right. Understand?
Okay, all right.
Mm-hmm.
Yeah, okay.
All right, and I get a sense too that the will has to be read under our laws. In other words, you could do whatever you have to do, but if you have a will, it's in Trinidad and Tobago, it has to be read and executed and all of that. So you can't go somewhere else, tell them take you to Canada and kill you, and then come back and read the will here. All right? So, okay. I hear you. Next person.
Sister Michelle.
Hi, good night, everyone. I have 3 questions. One, if the mutual will, right? You said cannot be changed, where the husband one die and it have to stay the mutual staying just upon whatever will you want make when they was alive, right? Let's say leave the will for children, whatever leave for children, and let's say one party, both parents die, right? And the children now have whatever left for them, the home or whatever, and they get married. Can they change that will?
If the 2 parties died and they left whatever to the children.
Right, and the children
then a deed will have to be done in the children's name, transferring the property into theirs, so it no longer belongs to the parent.
Because they die.
Right. So the will has to be probated and a deed done transferring it into the children's name. So the property is now the children's own. Okay. So one maybe decide I buy you out and just one person remain with it, or all 3 names or 500 names go on it as owning it. All right. That is transferred. So it's no longer in the parent's name. So that will was probated. It is no longer valid.
Okay. And the other question is, let's say your husband, or the wife, which one the party, right? And they have money and they put their wife or the other party as the beneficiary. Do that stand, or you have to make a will for that? The beneficiary stand.
You have money where? Have money where?
In a credit union bank and
you can put a beneficiary, but a lot of times the credit union, unit trust, and so will still require a grant in order to access that money. And the executor of the estate, if there's a will, would have to distribute when that grant is remember when you're doing administration, all debts have to be paid off before any distribution. So a lot of times the banks and credit union will wait until all of that is done, then to issue or to pay any beneficiary. All right. So sometimes I have seen in some insurance and so they pay it off without because there's a beneficiary they pay it off, but some require the grant of probate or letters of administration in order to pay off, even though there is a beneficiary. All right?
Okay. And the other question is, last question, what is the power of an executrix? Can they, let's say somebody died, they leave two persons in the house, but one person, the executrix, moving a third person into the house. Does she has that power? He has that power to do that?
Okay. When somebody dies and leaving a will, the executor of the estate is responsible for whatever asset to make sure that it is kept in a good state and all of that. If there's rent, if it's a rented property, they are supposed to collect the rent and all of that. If the property is can be rented, they can rent out the property. In the meantime, while the process is taking place to administer the estate, okay, they can rent it out. But as soon as they get the grant, they are supposed to distribute the property or whatever assets according to the will. Now, if it's a trust that the person has set up in the will, well, that's a different thing. All right, where the trustee now would have all the assets under the trust, and that trust is the one to administer whatever and manage the trust and all of that, right? But in terms of somebody dying and the executor doing all kind of things, no. They are allowed to generate income from whatever, if it's rent or whatever it is, they're allowed to do that, rent out the place, but all that money comes into the estate. All right? And it is only done until they get the grant. All right?
Well, thank you.
Okay, guys. Any more questions?
We have a question that was sent in.
Go ahead.
Right, so we have another one. And the question from the person, they said, my parents, my deceased parents got the house together that I'm living in presently. Right? So they live in the house, but their parents are dead. Right? Their mother has 6 children and 4 is for the father. Now the deed for the house is in the mother's name, and the mother is already dead, and they're living in the house. And it's been 21 years since the mother passed. So how or what steps can be taken to get her name off the deed and her name on the deed, meaning changing her dead mother's name from off the deed and putting her own name on the deed?
Okay, it depends that if the mother left a will, it could be 100 years ago that the mother or whoever, the person died and left the will, whoever they leave it to, all right? If the executor of the estate is still alive, that person can make an application for a grant of probate, and only upon receiving the grant of probate, the property can be transferred to the beneficiary under the will. If the person did not leave a will, and I'm guessing that in this case, the mother did not leave a will, all right? If she had a husband at the time of her death, half goes to the husband and half to all her children, whether the inside children, outside children. If it's a man, whether inside or children, outside children. Half goes to the children, all right? If there's no parent or no spouse, I should say, at the time of the death of the person, then everything has to be shared equally among the 10 children. So the house now, if they will have to do letters of administration for the estate of the mother with, the mother's name is on the will, right? On the deed, sorry. So you have to do letters of administration for the mother's estate. All right. All 9 children will have to give 1 or 2 the consent to make that application. Now, making the application doesn't mean that you own the property. You just get the consent to make the application to be the personal representative of all the other children. All right? But the house now has to be shared equally among all the children. So one could decide, well, I want my share. They could sell the property and distribute it the 10 ways, or one may be able to buy out the others. However it is they want to do it. All right, I guess they want to continue to live in the house, so it will have to go on everybody's name, or they buy out each other. That makes sense? And answer your question?
Yes, but the person said that there was no will that was left. So does that change anything?
That's what I'm saying. If there's no will, it goes under letters of administration. Now, letters of administration is not a letter, it's a document you get from the High Court after an application is made. When somebody dies without leaving a will, the law steps in to say who can make an application to handle the person's asset and who can benefit. All right. So the first person who can make the application to handle the asset is the spouse. If there's no spouse, then it goes to the children. If there are no children, then it goes to the parents. If there are no parents, siblings, and it goes down nieces, nephew, and cousins, and whatever. It goes down that way. All right, so it's next of kin. So if the mother did not leave a will, an application to the court for letters of administration will have to be done. And only when that is granted, the deed could be done in all the children's name, or one could say, well, I go buy all out, and one would inherit it, and the others, that person would pay out, the others pay off. So the house could be valued, or the land and everything could be valued, and the others, one person may be able to pay out the others or whatever, or they sell the property and they split the proceeds. Understood?
Okay.
Okay. Yes, I understand.
Sheldon.
Yeah.
Yeah, that's all, Sheldon.
Yes, good night. I heard you said in the question that you just answered there. Now, if you have the 10 children, and let's say, and you're doing the application for the letter of administration, and one of the children passes away, but that particular child has children, that person's share of the property goes to their children, correct?
Yeah. Once that person dies after the parent, if they die before, they are not entitled to it. It's only the surviving, after the parent has died, only the surviving children would inherit.
Okay. Okay.
All right, so if that person dies after the parent, then their children, and that ties up everything, because letters of administration, or if the person left a will, that has to be dealt with first before you can deal with the mother's estate now. So when somebody dies within the family, that it takes it a whole different road. So if you have 10 people and 5 died after the mother, the longer you wait, more people will die. And so if 5 die after the mother, it takes it into a place where you now have to deal with each person's estate before you can do the mother's estate. All right, so it takes it into a rat hole there. All right, so the quicker that you can do it, it is better.
In this day of technology, where you don't have to go into the bank and saying you could do things online, my spouse passes away and I have access to their accounts, what happens if I withdraw the funds from the accounts? Is that legal, illegal for me to do
That is
that?
illegal. If once your name is not on the account and the person dies, they can't give you the authorization to withdraw anything. All right. Now, when you're doing the grant of probate, it's everything the asset as of the date of death. All right. So whatever is in the account on the date of the death of the person, that is what is going to be distributed, has to be distributed. Okay. So if it is that you go in and take out money, the bank, they have cameras, whatever it is, and they could say who took out the money.
No, but we're talking about online, you have access to their account. Remember your spouse and thing, you might have access to each other's account.
Okay. Well, it may be difficult for the other beneficiaries to prove that it was you who took the money, right? So if they cannot prove that it was daddy who take out the money or whoever take out the money, they will have to prove that in order to take you to court for whatever was taken out.
All right. Because they may not even know how much money the person had in their account and all of that.
Remember, okay, when somebody dies, whoever is administering the estate will have to write to the banks, write to their job and all of that to find out how much was in each account at the time of death. So that will be available to the beneficiaries.
Okay. All right. Any more questions, guys, before we move on?
We have other questions. It's one asks, if a woman is divorced and has a house with her husband, can the woman still do a will leaving that property for her children?
Her name is on the property, on the deed?
Yes. But is what she already divorced the husband?
Well, it still depends on how they held the property. Last night I mentioned if they held it as joint tenants, it means that the both of them own the whole property and the last surviving person inherits the whole thing. If they held it as joint tenants, meaning that she has a share and he has a share, it means that her share can be left to whomever she wants. So it all depends on how they held the property. And usually when it's husband and wife, especially if there's a mortgage or so, it is usually held in joint tenancy. If there's no mention of either one, it is joint tenants.
You got any more questions?
Yes, we have two more questions. One, the second one is asking if you have clients in the USA.
If what?
If you have clients in the USA.
No, I don't. But if it is that it's something to deal with the USA, US law is different. The person will have to get an attorney in the US to handle whatever. If the person has assets here and the person live abroad or so, they can do an application here even though they are living abroad. All right, every document will have to be sent to them. It has to be notarized and all of those things and sent back to file. So it's not impossible for somebody who lives in another jurisdiction to make to file things here or make applications here. Right?
Okay, I see that we have Auntie Gil's hand is up, but we have one more question first, and then we'll go to Auntie Gil, right? So the question is, what can you do if the last standing person to inherit a property with the house and land transfers it to their kids? And if, hold on, I'm trying to, okay. So what if you do the last standing person to inherit a will, inherit a property with their house and land and transfer it to their kids? And if they don't do so, or if they don't do anything, what happens to the land and house?
Okay, the last standing person inherits the property, all right? If it is that they did not do a will, it goes to their children or their next of kin, All right. So whoever had owned it before, that their family or children or so cannot inherit, is the last standing person with a joint tenancy. All right. The last standing person inherits the whole thing. Why people do that also? If you have a property and it is owned by, let me say, two persons, all right, as joint tenants, those two persons that before they die, they each had 10 children. Okay. And let's say the both of them die. Now you have 20 people owning this one property. All right. And to deal with that property with those 20 people, it becomes more and more difficult. So what is normally done is to leave it as joint tenants, right? Leave the property as one, and the last standing person can deal with the property after. All right, so that's the difference between the tenancy in common and joint tenancy. But whoever is the last person can deal with their property as they wish. They can give it to the vagrant, they can give it to charity, whatever they want to, because they are the last surviving owner of the land, and they can do with it as they want. Okay?
Okay. Thank you.
Good night, everyone.
Good night.
If I have an account and I have the account on a joint account with my husband and I, if I die, he can take out what it is. He don't need to go through all that. Eh?
Well, if it's a joint account, all right, usually with a joint account, I'll say the last standing person gets everything. If it's a joint account, he would be able to access that. If it is, I don't know, you see the bank have different types of accounts, right? If it's an account where both of you have to sign in order to access the money, all right, that is different, all right? And therefore, you may the surviving person may have to do letters of administration in order to access the money that it was left in the bank. May. All right, it depends on the type of account it is. All right, but if it's a joint account, all right, it means that the other person automatically gains all of it. It doesn't fall under the will of the deceased.
Okay. All right. And my next thing, we have our own husband and wife. We have our own home, right? And we have, presently, we have one daughter and one granddaughter. Say like today, tomorrow we pass. Let's say whoever pass, do we have to go through that system, or our daughter would be liable for the house or whatever?
Okay. If it's two of you and that own the house, as I said, and one party die, if it's in joint tenancy, all goes to you. All right? And then now, if you should leave a will, you can leave it to your daughter and your granddaughter. Or if you don't do a will, it will have to go under the law of intestacy, meaning that you die without leaving a will. So letters of administration has to be done, and the property will have to be distributed as under law. Now, because you have one daughter, everything will go to that one daughter. If there was more than one, it could be distributed. Now, if it is that, let's say it's the husband and the wife dies or so, and the husband is the joint tenant, and let's say he has outside children all over the place and whatever, that property would have to be divided among all the children if he doesn't make a will. All right?
All right, he doesn't have any outside children, but
I'm just talking in general. All right, I'm just talking in general. All right.
So that means, in spite of, we still have to do a will. Then we still have to do a will.
It is better if you do a will instead of the daughter having to go to make an application for letters of administration, because I told us, I don't know if you were here last night. With letters of administration, it takes a long time to administer because one, there's a backlog at probate registry, and two, the probate registry has to be sure So they have to do their investigation, put it on papers, whatever they need to do to ensure that you are the rightful person to inherit the assets of the person. All right?
Wow.
So it takes a while for, even though it's one daughter you have, they have to be sure it's one daughter. All right, they have to be sure of what the assets are and all of those things. So it takes a longer period of time in order to deal with the assets. So it's better if you make a will.
Wow. Wow. Okay, thank you.
And sometimes it takes years. As I told you all, I have some things from 2019 that I'm now getting. We are in 2025. I am now getting the grants for it.
Wow. What happened if the executor dies?
Okay.
So the person dies and then you find out that the executor is also dead. What happens?
All right. So then any one of the beneficiaries under the will can become the legal representative of the estate. All right. And they can make an application with the death certificate attached and all of that for letters of administration, not grant of probate, letters of administration with the will annexed. So how it is going to be distributed, the asset is going to be distributed is according to the will, but letters of administration will have to be done because the executor has died. So that person has to step into the shoes as a personal representative of the estate. All right?
Okay.
To make the application.
So the Janet, I'm seeing your hand and I'm seeing Beans.
Yes, good night, everyone. Sister Marilyn.
Hi.
What about if you have a property? Isn't it better to do a deed of gift than a will for that property?
Okay, we mentioned that last night. You can do a deed of gift, but as soon as you transfer the property, it belongs to the other person. They can put you out.
Yeah, but
at any time. And I have seen it done already. Don't say that it will never happen to me. I have seen it done already. So if you decide to do a deed of gift and leave your house to your only daughter and some man come and bamboozle her head or some woman come and bamboozle your son's head and they put you out on the street. All right? So what you will have to do if you want to do a deed of gift, you also give yourself a life interest in the property. So they will inherit it after you die. Okay? So you can do the deed of gift and give yourself a life interest, and upon your death, it is automatically your daughter or your whoever owns. All right?
Yeah, well, yes, I know that. I know that because my husband did one for me and then I did one for one of my daughters. So I know about that. But what I was, instead of going through the problem of the will, the ups and downs, debate and all of that, I was wondering, the deed of gift is not a better thing to do, but
Well,
make sure.
The difference between the two, let me just think. The difference between the two, when you do a will and the property is being transferred into the names of others, you don't have to pay stamp duty and all of those things.
Yeah.
But once you're transferring the property before, you have to pay the stamp duty and so, which is a lot of money, a lot of times. So if you don't have that money up front, it is better to leave it in the will. Right, than to do a deed of gift or transfer the property to the person. Okay?
Thank you.
Beans.
Yeah, that question that Professor asked about if the executor dies soon after, and it's one of the beneficiaries can go and make an application. Going back to what Professor asked earlier on, what if all who's supposed to be the beneficiaries were never told that they were beneficiaries? How will anybody know they have to go and make an application?
Okay. I think yesterday what I mentioned is that you need to place the will in the probate registry. In case of your death, don't put it in a safety deposit, but wills can be destroyed easily. I have one case where this woman, she saw somebody burning some rubbish and gave them, just burn that for me. And the person kept kept the document that and when she looked, it was the will of her husband who had died. And wills can be destroyed very, very easily. And there's no way to say, even though I know Daddy had made a will or whatever it is, and you have no proof of that or nothing to show that he really did make a will, then it will have to go under intestacy, meaning that he died without a will. All right. So if it is that the will is in some safety deposit box that nobody could access, or you don't know, or whatever is in his whatever his assets are, it will have to be administered under letters of administration. All right.
All right. Well, folks, it's 9:30, so
Yes.
we've come.
But just before we wrap up, we just have one more quick question. The probate office that you spoke about, right? That's a physical office, right?
Yes, in the Hall of Justice.
The Hall of Justice, okay. Because that was going to be the next question, where it is, so that we would know.
Yeah, and one last thing, if the estate is under 4,008, you don't need an attorney. You can make an application to the probate registry directly and administer that. Okay, so maybe you have a little bit of money in the bank or so, and it's less than 4,008, you can get letters of administration to handle that amount, but you don't need an attorney. Anything over that, you need an attorney. All right?
You know, as we close off, Marilyn, a couple of things. One, some people might say, well, I don't have property, I don't have no cars, I don't know houses, I know nothing. You know, so what's the sense of making a will? What would you say to somebody like that? Because they really don't have anything.
You'll be surprised at what you have. And even, you know, you can make a will leaving all your estate and whatever to whomever. So in case you may come, even after you die, somebody you may inherited something that you don't even know you had. That is covered on your will to leave to whomever you would want to leave it to. All right. So you can leave a will leaving all my property, maybe it's your clothes, your jewelry, or whatever it is, to whomever, and you have to do the clause, all my residual estate to whomever. All right.
Residual estate, things like if you write a
anything
book.
that is not mentioned in the will, the residual will be anything that is not mentioned in the will. That clause has to be included in the will to cover anything that would come all unknown to you.
All right. So like write something, write say music and things that you know, all of that would be okay. All right. Okay. Well, folks, we've come to the end. We want to say thank you so much
Thank you all so
again.
much.
But before you go, Marilyn, also would you care to give your number if people want to connect with you? I don't know how you feel about that. We're somebody looking for a lawyer. What do they do?
Let me tell you all. I work with the state, so I do not do private work. All right. I can do things like non-contentious things like wills or so personally, but in terms of litigation and so, I cannot do it because I work directly with the state. All right. So if it is something contentious or so, I would not be able to do it for you. I can recommend attorneys or so that handle those things. I can do that. All right. But don't, well, if you have something, don't think that I can handle it unless it's something straightforward, like a will or something that is not, doesn't involve going to court and filing things in court and so.
Understood. Well, once again, oh, okay, I see Beans raises and Beans are giving it 30 seconds. Go ahead.
I'm glad you mentioned trying to find a lawyer. Because what I understand about the system, lawyers have to be careful how they advertise. What can people do to be able to get in touch with a good lawyer when they do need one?
Well, there's the Law Association website that has a list of all the lawyers. You can go there and see And then a lot of times it's word of mouth. So you deal with somebody, and that's the greatest one. Somebody dealt with a lawyer, and that lawyer was really good, so they could recommend that lawyer to you or whatever. All right, but we're not supposed to advertise or have big grand signs and promise anybody anything, that kind of thing. That's not ethical.
Yeah. I always wondered about that. I mean, you see on American television, you see so much advertising on lawyers and that kind of thing.
Yeah, that's
And we
supposed
don't
to
have
do
that here.
The doctors and
Okay.
lawyers are not supposed to do that. And if you look at the signs, most times it is in a black sign, and it's not very big. Lawyer's office.
Okay. Lawyer's office, yes. Okay, so once again, Marilyn, we want to say thank you so much for gracing us with your presence and with your expertise. And we are grateful. We are more knowledgeable now. And so we thank you so much for sharing with us. Yeah, and so God bless you. Thank you.